Resuming debate, the honourable member for Toronto Centre.
If only there were an NDP member for Toronto Centre right now, Mr. Speaker. Toronto-Danforth. I would start by saying that I'll be sharing my time with my honourable friend from Hochelaga. And I'd also like to start very briefly by addressing one small point in the motion from the Liberal Party, which is the whole question of requiring the Prime Minister to speak under oath. We will be, at least I will be, supporting this motion, but I do want to suggest that this is a tiny bit superfluous. Any person in this House, any MP, including the Prime Minister, must tell the truth. It's a matter of our parliamentary privilege. Every time the Prime Minister stands up in the House, he is duty-bound to tell the truth. And so he actually already is, in the best sense of the word, under oath every time he's in the House. So we need a little bit more information from the Liberals on exactly what kind of process would perfect what the Prime Minister is already under duty to do. I rose in this House on May 21st to ask the very first series of questions, Mr. Speaker, on criminality involved in what we now know to be a criminal scheme. I referenced Section 16 of the Parliament of Canada Act and then Section 119 of the Criminal Code. The Parliament of Canada Act, I just want to say this is almost a symbolic point I wanted to make. The Parliament of Canada Act, Mr. Speaker, says in Section 16, no member of the Senate shall receive or agree to receive any compensation directly or indirectly for services rendered or to be rendered to any person, either by the member or another person, in relation to any controversy or accusation before the Senate or a committee of either House. It fits perfectly. It actually applies only to the Senate and senators. Interestingly, and here's the symbolic point, any senator guilty of this provision is liable to a fine of not less than $1,000, not more than $4,000. No jail time in this provision, Mr. Speaker. But you know what? Every person who actually gives the bribe, who isn't the senator, according to Section 16 of the Parliament of Canada Act, is liable to imprisonment for a term not exceeding 1 year. So the symbolic difference between how the Parliament of Canada Act is drafted so that senators actually can be bribed and avoid jail while somebody else involved in the same process, an average citizen, for example, goes to jail, I think is an absolutely symbolic statement of the state of privilege and indeed institutional corruption in that body. We all have seen, many of us have read in detail, the affidavit from RCMP Officer Horton, 80-some pages, where he mentions not only Section 119 of the Criminal Code and bribery, but he also mentions breach of public trust in Section 122 and fraud on the government in Section 121. I think all three of these provisions seem very clearly to be made out, given what we know about the quid pro quo arrangement involving at least Mr. Duffy and Mr. Wright, where Mr. Duffy's side of the deal would be to be silent, both in the Senate and in public, and the side of the deal for at least Mr. Wright and others in the PMO, quite likely, was that there'd be money paid back to Mr. Duffy so that he wouldn't have to bear the cost of the expenses he owed, and also that there would be some kind of rigging of a report coming out of the Senate so that it would actually go easy on Mr. Duffy. That was a key part of the quid pro quo as well. What I'd like to focus the remainder of my remarks on, Mr. Speaker, is the fact that we can't be blinded by the Wright-Duffy relationship as this is the direct participatory side, two parties clearly involved. But this whole thing is most clearly a scheme. Others are involved. We know of different aspects thanks to this very historically unusual insight provided by the affidavit from the RCMP. But assistance and participation, other than being the directly involved party, is part of our criminal code. And I would suggest with Section 22 of the Criminal Code that we can start, frankly, depending on what the evidence reveals, we can start with the Prime Minister. Section 22(1) says, with respect to a person counselling an offence, where a person counsels another person to be a party to an offence and that other person is afterwards a party to that offence, the person who counselled is a party to that offence, notwithstanding that the offence was committed in a way different from that which was counselled. Doesn't matter that somebody says, please go out and do a hit job by kneecapping somebody with a hammer, and that person uses an iron bar instead. Doesn't matter if the source of illegal funds in a transaction was originally going to be the Conservative Party's funds, and it turned out to be Mr. Wright's own funds. Either source is equally criminal, and anybody who participated, anybody who counselled that initial payment, if it was going to be the case, from the Conservative Party fund, would be equally guilty if it turned out another fund were used. There is also Section 21, which deals with parties to the offence. All criminal offences in the House, including the ones I've already read out on bribery, fraud against the government, breach of public trust, every one of them has an analog or an accessory life, which is that other people can be involved. They can be aiders or they can be abettors. And also in Section 465 of the Criminal Code, there can be a conspiracy. A number of people can agree to be part of a scheme. And so here I'd like to suggest that we move on to another character in this quite tawdry and sordid drama, Senator Gerstein. If we look at the whole idea of aiding, what we know to have occurred between Mr. Wright and Mr. Duffy, and if we know that being part of a common intention to fulfill the purposes of a scheme such as this is itself criminal, then boy, oh boy, what Mr. Senator Gerstein did by way of trying to interfere with Deloitte by going to a contact within Deloitte to see whether or not Deloitte's report could be stopped on the basis, on the shady basis that Mr. Duffy was paying back the expenses and therefore somehow or other the matter would be moot, only to have Deloitte say, no, we'll be going ahead, but telling him they were not going to come up with a firm finding on the question of residency, which gave an advantage to the PMO with the rest of their scheme, which was it told them how to go about structuring the rest without pushing Deloitte any further. It's very, very clear that this is interference with respect to Deloitte in a way that assisted the broader scheme. And I, for one, think that the evidence that's already in that 80-page affidavit is more than enough, if it turns out that what is said there is true, for Senator Gerstein to be charged with being part of this scheme. I'd also like to mention something else that's separate. Keep in mind that some of this stuff may have only gone so far and then didn't quite end up being completed. And that might also include Senator Gerstein. So keep in mind that attempting an offence is itself a crime as well under Section 24 of the Criminal Code. Let me turn now to what happened after the scheme had initially occurred, and then there was evidence beginning to emerge, and there was what one would call a cover-up. There's a whole section of the Criminal Code called Misleading Justice. Section 131 of the Criminal Code speaks of perjury. Now, perjury is not just something that happens when you're in a court of law and you tell an untruth, but subject to the rest of this section in Section 131(1), everyone commits perjury who, with intent to mislead, makes before a person who is authorized by law to permit it to be made before him a false statement under oath or solemn affirmation by affidavit, etc. So the statements taken by the RCMP and revealed in this affidavit fall exactly within the scope of this provision. I would draw everybody's attention to how the RCMP has square-bracketed comments throughout that document explaining in a number of cases where they clearly feel that somebody giving them testimony did not tell the truth. And I have to say it here that one of the highlights in the affidavit from the RCMP perspective was that Senator LeBreton was not telling the truth, and that was specifically in the affidavit. Perjury is also a crime, as is obstruction of justice. I won't go into the details. And finally, the lawyers. It is an unethical practice for any lawyer to knowingly be involved in assisting a criminal offence, such as may have happened in this case. I, for one, Mr. Speaker, hope that there are members of the legal profession that will be drawing this to the attention of the law societies who are relevant to the lawyers involved. Thank you, Mr. Speaker.
Questions and comments? The Honourable Parliamentary Secretary to the Prime Minister.
Thank you very much, Mr. Speaker. As I said to an earlier question and comment, it's unlikely that I'm going to agree with many of the things the honourable member had to say, Mr. Speaker. But I can't help but comment on a member for Malpeque, Mr. Speaker. How odd it was to have the Liberals put the member for Malpeque up to talk about ethics in government and ethics in expenses, Mr. Speaker. This is coming from a member, Liberal member for Malpeque, who claimed expenses, I don't know, thousands of dollars in expenses for a house he said he owned, but oops, he didn't actually own it, Mr. Speaker. And he was being cheered by the member for Vancouver Centre, guilty of Election Act charges, Mr. Speaker. Sitting next to the members from Saint Laurent Cartierville, guilty of Election Act charges, Mr. Speaker. My gosh, Mr. Speaker, how funny it is to have that ethical standard by the Liberal Party, Mr. Speaker. But I wonder if the member opposite might comment on something, because as I said, we're not going to agree on a lot of things. But I wondered if you would agree with me that the fact that the Liberal Party refused to allow their leader to speak on this issue is an indictment of the fact that they don't trust him to speak not only on this issue, but on any issue. That they would, in essence, agree that the Liberal leader is in way over his head, not only on this, but just about on every topic that matters to Canadians.
The Honourable Member for Toronto-Danforth.
Mr. Speaker, I honestly don't believe that question deserves the dignity of a response. It's clearly part of a diversionary strategy that has nothing to do with what's in the House at the moment. Thank you.
Questions and comments? The Honourable Member for Cartierville, Saint Laurent. Thank you, Mr. Speaker.
For his speech. I think it's the best speech I heard from him since in the House. Very well informative and very precise. He said at the beginning that in the Liberal motion we asked the Prime Minister to testify under oath, and he made the point that we are under oath in this House. The problem is that we want to have answers on the oath, and the problem is that the Prime Minister is not giving an answer in this House. So we'd like to find a way where the Prime Minister will be in the obligation to answer very specific questions about, for example, who knew about the deal with Mr. Duffy in his office, and why these people that knew are still working with the Prime Minister.
The Honourable Member for Toronto-Danforth.
Thank you, Mr. Speaker. What I would say is we don't necessarily have to think about a specific institutional context when it comes to extending what context the Prime Minister could testify under oath. Keep in mind that we've already seen an example of interviews of people involved in this scheme that were revealed in the affidavit. The Prime Minister, I hope, at one point, given what has been revealed so far, might himself be subject to such interviews. He will be under oath at the time that he gives such testimony.
Questions and comments? The Honourable Member for Thunder Bay Superior North.
Thank you, Mr. Speaker. Mr. Speaker, a woman named Alison Snowden, a lifelong conservative, contacted CTV News recently and said she was disillusioned by the party she supported for decades. And she wrote in an email, quote, "It started in 2006. First, the Prime Minister tried to put all of the chiefs of staff in place who were loyal to him. Then they started planting their people in the minister's office at director's level. Over time, the ministers were marginalized and all the staff became Stepford wives to the PMO. Later in a phone call, she went further, stating, quote, "There's nobody inside anymore to stand up and say, you can't do that, it's wrong." She said this was because everyone just follows orders there. So after 40 years, she is, quote, ashamed of this sort of behavior. So my question to the honourable member on my side here is, what can we do to get MPs standing up and working for constituents, their conscience in Canada, instead of parties?
The Honourable Member for Toronto-Danforth.
It's a slightly off-the-topic question, Mr. Speaker, and I will answer very briefly. To say that I do believe the House of Commons legitimately functions on the basis of strongly of a party system. I do personally wish we had more independence, because I actually do think it injects energy and a perspective that might not otherwise come through party dynamics. But honestly, I think we need a House of Commons oriented around parties, and we need a Senate that is completely distanced from party politics, especially of the sort that uses the Senate as a home ground for fundraising, speechifying, and all kinds of other things that have nothing to do with the senator's job.